Good morning. I'm Mark Kimball. Agenda item 1 is the call to order. It is 10 a.m. on November 20th, 2025. I call this meeting of the Citizens Clean Elections Commission to order. With that, we will take attendance. Commissioners, please identify yourselves for the record.
Christina Werther.
Galen Payton.
Sam Crunt.
Thank you very much. I'm Mark Kimball. We have a quorum. Item 2, discussion possible action on the minutes for October 23rd. Commissioners, you have the minutes from our October 23rd meeting in your packet. Is there any discussion? Hearing none, is there a motion to approve the minutes?
I move to approve the minutes for October 23rd, 2025.
Thank you, Commissioner Werther. Is there a second?
I'll second it.
Thank you, Commissioner Payton. It's been moved and seconded that we approve the minutes from our October 23rd meeting. I will call the roll. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump.
Aye.
Chair votes aye. The minutes are approved.
Chairman,
Uh,
this is Commissioner Titla. I vote aye also.
Thank you, Commissioner Titla. The record will show that we have all 5 members of the commission present. Item 3, discussion possible action on the executive director's report. Tom?
Yeah, thank you, commissioners. Happy Thanksgiving. Early. I hope you've made your travel plans solid. I wanted to highlight, Gina was appointed to the National Voter Registration Day Steering Committee. I don't know, you all probably know this from now, but we have been actively involved with the National Voter Registration Day holiday for, I think, 10 years almost now. And the holidays existed for 13 years, and having that day focused on voter registration in September has resulted in more than 6 million voter registrations. And on the board, on the steering committee rather, with Gina will be the Kentucky and Minnesota Secretaries of State, 2 elections assistants commission members, and folks involved in civics and other issues around the country. So that's a very exciting, and Gina and Avery and Alec and have worked to be on the ground for the National Voter Registration Day programming for a long time now. So that I thought was a really cool thing. We will have our second town hall in partnership with Telemundo. That is going to be recorded on December 1. If you're interested in attending, please let us know. We have 10 seats available to us, we believe. And then we had, since we last met, we had the local elections for November 4th. Excuse me, and we were able to provide, I think, a lot of background and information to some of the local television stations, which was, I think, a good thing for us. And then finally, I did want to post so you have them, the October voter registration totals. As you can see, we've kept up a pretty active outreach agenda. The strategic partnerships meeting that we all went to was an interesting, good opportunity to be in touch with members of different tribal communities and counties. We met in Maricopa, or just outside of Maricopa. And Avery was featured at Mithila Vota's leadership training as a speaker. And we're continuing to work on getting ready for next year. And Gina right now is coming to us from the Mechanics of Democracy Lab AI Elections Boot Camp. And then meanwhile, Administratively, Mike has been fielding calls from and getting candidates set up who are getting ready to run clean, and that's been a pretty steady, I think, pretty consistent level of inquiry, and folks are starting to get signed up for the workshops. I think that really is sort of the things that I wanted to highlight for the report. But if you all have any questions for me,
I have a
happy-
question.
Sure.
Commissioner Payton?
The workshops that you have
Yeah.
for these people that are doing clean elections, how long are they? How many days?
Well, they're not days.
Oh,
I mean, I think we try to get them in and out in depending on how many questions they have in around an hour. The reality is that the main points that it hits are really the main points that most people have no problem with once they understand, which is what kind of money are you allowed to take? What kind of paperwork do you need to file? When do you need to file it? And then understanding, reporting deadlines and all that kind of stuff. Once you get past in my view, and Mike can speak to this too, once you get past the seed money caps, which are pretty complicated, right? Like how much money you can take, how much money you yourself can give, how much money your family can contribute. And then how much overall seed money you can take. That's probably, I think, the most complicated part of the underlying money piece. And then the next step is getting people to understand that because all of the money is in one account, even though these categories have to be met, that doesn't mean you're constantly accounting for that, right? There's no segregation of the dollars. It's a matter of you making sure that there's enough money in your account to cover each one of the categories that you're obligated to cover. Those are the two most complicated things about it from an administrative perspective. As far as sort of the admonitions and things that we're working into it, that's something that we, I think especially after today, hopefully with the rule we have up, that's something that we've talked about, hitting more. But our goal with this workshop is to do two things. It's first of all, to demystify rather than mystify. In other words, it's to try to say this is less complicated than you think, not more complicated than you think, because a lot of people come in with the idea it's very complicated. And then second of all, really to make sure that they understand that we will answer all their questions. In other words, that to develop a relationship where if they're in contact with Mike, and I will tell you this anecdotally, and I may have said this last month, but I was out in Goodyear in I think September, and a couple people would run clean before. I mean, the first thing that they, come up to me to say, I mean, this is not, to say how easy it is to get a hold of Mike, how Mike answers all the questions, and that's the vast majority of our folks. So that's really the purpose of the workshop. So it's not, if we can get that relationship going. Now, in some cases, as we've seen, that doesn't happen, but we haven't oriented the workshops around the outliers. We've really oriented around trying to make sure that people understand that we're there to answer their questions on an ongoing basis so that they don't run into trouble. Is that answer your question?
So it's multiple workshops, but they only have to go to one.
They can go to as many as they want to as they have questions. I mean, the idea. The philosophy we've had for this has been we're a government agency, right? The first instinct people have when they're dealing with the government is it's going to be negative, it's going to be opaque, and it's going to be evasive. So the first thing we do is try to knock down those barriers. The next thing we do is we have this program that, especially in the two areas I'm talking about, seems very complex, right? Because there are these specific caps you have to work around, and until they click, they just feel very complicated. So getting that done, getting them to understand, what the $5 process, what they need, and then having that relationship continue. So I'm not sure. Have people come back twice? I mean, I'm sure we do have people come back on an ongoing basis to develop that. So I think this year we've already said that we're going to emphasize the need to get your filings in on time, because that's been our big issue the last year. But that's sort of how we've been doing it.
Okay. Thank you.
Thank you, Commissioner Payton. Are there any other questions or discussion from the commission? Thank you, Tom. Moving on to item 4, discussion possible action on Secretary of State's October 16th decision regarding the No Labels Party name change. Commissioners, you will recall last month we had some questions about this decision as part of the executive director's report. Based on that discussion, staff has gone out and researched the decision and starting to examine the voter education implications of the decision. And let me just say personally, as a registered independent, I'm very concerned about this decision by the Secretary of State's office to allow the No Labels Party to change its name to the Arizona Independent Party. I think our role as the state's official voter education organization, this is greatly going to complicate our job. So that's what I hope we'll discuss today. Tom and Gina have some brief thoughts on this, and then if you have questions, we can address those. Bill Richards, who is our counsel, is available if we need to go into executive session, but I think the majority of this discussion should be in open session. Tom, do you want to start?
Yes, Mr. Chairman, thank you. I have a PowerPoint that tries to summarize, I think, the upshot of what the memo we provided does, and then Gina, I hope we'll be able to talk a little bit about some of the aspects of the memo that get into voter education. Just to, so Gina and I this morning, presented a very similar very similar presentation to the county recorders. And I think we think that went well. And we had, I think, almost every county recorder's office was represented on that call. So, that is something we're invited to do in part because of, the county recorder's concerns they've expressed to us. So I think I wanted to sort of talk real quick just to ground us in the timeline here, if we could. I think if we could go to the next slide, Kathy. Sorry. I think that's the next slide. I have a copy of the thing. Yeah. So this is the best we can tell the timeline here. October 8th, No Labels submitted this request. The next week, the secretary approved it, and then at least the first notice we can find of this being contemplated and approved is this October 17th story in Axios. Since that time, obviously, many of you expressed concern at the last meeting about this. There were counties, some parties expressed concerns over this, and this has been coupled with the idea, which is a little hard to understand if it's a policy statement, or something that's part of implementation, or a just sort of a urging. But the secretary's office would like agencies to just stop using the word independent to describe unaffiliated voters altogether, which in the words of the Secretary of State has to do with because that sort of essentially belongs to the party now. And so, all these things taken together kind of create the issue, that we're talking about. December 1 is when this is supposed to start to happen. Although there may be implementation already happening on the Motor Vehicle Division website, where Voter Service Arizona, we're not actually clear on what's going on there exactly. I guess if we can go to the next one. Just to boil down the legal aspect of the memo, as best I could, and that's, my analysis anyways, right, is and I couldn't fit this on one slide with the font working out. I guess I'm just not good enough at PowerPoint yet. So basically, this is a question of, like, in my view, it's between regular and irregular election administration decisions, right? Typically, you've got some affirmative statutory authority. Typically, you don't take on statutory silence as a basis for a new power. Typically, you've got some notice. Typically, you've got some effort at alignment with election officials. Typically, you avoid late cycle changes that affect voter registration systems. Typically, you try to balance the First Amendment interest with the state interest, rights of voters, parties, and other, right? You're trying to be predictable. You're trying to be transparent. You're trying to be consistent, right? I mean, these are pretty universally, I think, acknowledged principles. So, you know, as to boil what I've written down, if we go to the next one, here we've got an action taken in the face of statutory silence that's treated as creating authority. We have no notice of the pending decision. It's unilateral. The legislative structure are not considered in any record we've seen. It's late. I mean, for purposes of voter registration, granted that there may be a push to register more voters in over the first quarter of 2026 leading up to the primary, but nevertheless, we're, something like 3/4 of the way through signature gathering. And then the way the memo that I believe you all had a copy of frames this is as a near absolute First Amendment right on the part of the party, which is inconsistent with the position the state had taken up until literally July, when the Ninth Circuit said, no, in fact, where there's a legitimate interest in voter confusion, in administration elections, all that stuff, the question is what the burden is on the party in comparison to that, not just the party's sort of unilateral right to do anything, because the party is involved in a quintessential state action. Elections are state action, period. There's not, you can't get around that by delegating. You can't get around that by so parties have First Amendment rights, absolutely, but they aren't absolute rights. And then again, there's a unilateral benefit to one party, which is sort of odd. So that's really, boiling all the words I wrote down to this is the principles I think that you can extract from them. This is an irregular decision. The next, I guess we'll go to the next thing. So we anticipate some legislative action on this, some judicial action. There are pros and cons to both. I tried to sort of outline them. I think that the big, I think you can imagine the pros, some kind of statutory clarity, as Gina will talk later. This is right now an ongoing issue for this party in particular, and maybe an ongoing issue statutorily. There are problems with, you got to try to make, if you want to undo this decision, you got to try to make it retroactive. You've got to try to, and you're implicitly, in a sense, validating the irregular administrative decision to do that. So it's, there's pros and cons. Then if we go to the next slide, judicial similarly, if someone were to file something that got an injunction that would, allow a pause, a reassessment at a minimum, maybe avoid wasted resources. But obviously, the results there are never certain, and there is a possibility of deference to the Secretary of State's office, assuming there's someone with, proper standing to bring the action. So if we could move to the next slide, then, we kind of think you got to, in terms of looking at this, not necessarily just from the commission perspective, but how this issue ought to be addressed if you're, of the belief, which I think my memo makes pretty clear, it's staff's belief that this is a bad decision. You kind of got to look at both of the ways you can address it if it's going to be addressed. We don't and haven't typically had a lot to say about this level of administrative decision. But I think, as Chairman Kimball said, because this, directly impacts voter education efforts, we have already heard from county recorders about their concerns, because there's not, I mean, I'm not aware of at this point, like, any public document on the secretary's website that says X is going to happen on Y date. B is going to, these things are all going to happen on this date. Like, like the map, the way forward, right? And how that's going to work. I don't know that that's been made available. If it is, I don't have it. And I'm not necessarily saying I should have it, but if you're going to go from on today to December 1, where some number of voters who are current members of the No Labels Party, so the 40,000 folks or whatever, are going to become American Independent Party people. And then once the MVD website changes, right, that's where something, I can't remember the exact statistic anymore, but was it 90? That's a very large percentage of people register there. I mean, that's once that goes online, I mean, that's instantaneously going to, bring about this this confusion. And we know from the California experience that we cited in the memo, that similar situation 10 years ago, something on the order of 73% of folks believed they were registered believed they were not a party, they were an independent, and nevertheless ended up in a party called the American Independent Party. So I think that's sort of the policy landscape as we see it. I'm happy to answer questions about that from you, obviously. And then Gina, I think, has has given some real serious thought to the voter education strategy around this and support. The one other thing I would note, is that, whatever anybody thinks about our voter education authority, the Clean Elections Commission Voter Education Guide is the only thing that comes from the state that goes to every single voter in the state ahead of the primary. So, so even if you say, well, this isn't mandatory, that's not mandatory, that's optional, you don't have to involved with that. The fact is that the last word that anybody's going to hear from the state of Arizona about this issue and how to address it as a voter is going to be in the primary election voter education guide. So I think that, all other debate aside, I think that's a pretty big stake that we have in this decision and making sure that everybody gets it right. So.
Thank you, Tom. Gina, do you want to weigh in on this now?
Yes, Mr. Chairman, Commissioners, thank you. I don't have slides, but I will just jump in and speak to the voter education components of this. I want to start by providing a little bit of background on the voter registration process. So I know in the ED report, Tom shared with you the current voter registration statistics, and I just wanted to highlight that the No Labels Party has less than 1% of registered voters of our electorate. And then we have this other category that is referred to as other, as you'll see in the ED report. And that is the second highest block, coming in at 34.37%. So the other names on there, Republican, Democratic, Libertarian, No Labels, and Green, those are what we call recognized parties. They have gone through a process to obtain recognition at the state level to appear on the statewide ballot. So they have that precious ballot real estate. When a voter registers to vote, if they do not select one of those recognized parties, they are lumped into this category called other. That could be an independent voter, someone who is unaffiliated with a party. It could also be a voter who considers themselves a member of a party that does not have statewide recognition, such as the Constitution Party that you might see active in other states. So a voter who, again, is not registered with one of those recognized parties, they are in this other category. And that's what we often refer to as independent voters. And that makes up a very large block of our electorate. We've seen in Arizona history where it's been the highest voting block in Arizona. So when we are considering what this impact will be in terms of the name change, first, and Tom sort of alluded to this, I want to stress that this is not a simple fix. It is not a one and done. It is ongoing voter education. This is something that will continue to cause voter confusion several election cycles from today, because we have a 3 decades, 30 years of history in Arizona using the term independent and what that stands for. We've trained but voter behavior has been produced because of that terminology and what it means and how they interact with the voting process. So as Tom had mentioned too, trying to stay away from the term independent when we've had it ingrained in Arizona voter and their behavior, it's just really not feasible. And to say that it belongs to a recognized party now, it's going to cause mass confusion. So the way that we are viewing this from a strategic standpoint in terms of how do we educate Arizona voters across the state and future voters, it really comes down to, this is not so much an awareness campaign. We don't look at it as a, stop what you're doing, state of Arizona, look at this change. One, that just wouldn't be an effective use of dollars. And two, it really highlights a particular party. It brings emphasis to this, and we're not promoting a party. Really, we need to look at this as procedural voter education, identifying each of the touch points that the voter will interact with through the voting process. First and foremost is going to be that voter registration process. As Tom had mentioned, the majority of voters do utilize the online system, the MVD system. So when you're going through that system, you get a drop down, and in the drop down there are fields that you can select. Effective December 1st, from our understanding, is that drop down will reflect these new changes. However, there's really no source for voters to go to understand what those drop downs mean and the path it now sets them on going forward. Once a voter gets registered, then really the next point of impact that we're seeing here could be, who are they eligible to sign petitions for if they're supporting a candidate? Are they truly an independent voter? Are they truly unaffiliated and they can sign anybody's petition? Or are they part of a recognized party now under the No Labels AIP party and can only sign those candidates? So we'll see a touch point there. And then we'll also see a touch point, and this is where we're going to see a lot of stress and pain, is in the primary election. So again, we've had 30 years of our open primary system where an unaffiliated voter, an independent voter, can make a party ballot selection. And so that's really important there. It is a party ballot selection because in primaries, the ballots are created by recognized party. So we've had a 30-year history now of telling independent voters there is no such thing as an independent ballot. An independent ballot does not exist in the primary where you have all party candidates on there. But now we would be telling voters, well, there's the Arizona Independent Party ballot, and that might cause confusion about what they expect to see on that ballot. Do they expect to see just AIP candidates, or do they expect to see what has commonly been referred to as an independent ballot? Again, that doesn't exist, but are they expecting to see all party candidates on there? This could cause confusion and delays at polling places. We would have to train poll workers how to interact with this. Is there any recourse for the voter if they, said, that's not how I register to vote. That's not what I meant. When voters are filling out a paper form, the counties right now and the Secretary of State's office and looking at the election procedures manual, they're working through clarifying language about what voter intent means when they write something on the form. Did they truly mean, oh, I want to be unaffiliated, that type of independent, or do I want to be recognized AIP party? So we'll see, again, touch points there that we need to provide procedural voter education on for our voters. And then going back to candidates, we'll also see education needs there, because does a candidate understand, hey, if I want to run for office, do I go what we call the statute, the 16341 process, which is the process for unaffiliated candidates, independent candidates to qualify for the general election ballot. They're not on the primary ballot. Or does the candidate decide, hey, I want to run under this AIP banner now, but I'm now in a primary and could potentially be primarying other AIP candidates if we run for the same office, and I have to win that and advance to the general election. What does that mean for the clean candidates? Do they understand, well, which path you're going down, determines the funding you're eligible for? So there's going to be voter education on that front too. So again, we really look at this as it's not a one and done. It's going to be an ongoing voter education issue. We will see lots of confusion from voters. The other thing that I want to point out is the media. We've had our open primary system since 1998. We have a significant amount of independent voters who are not participating in the primary election. A lot of that comes down to they often say, I didn't realize that I could, or I didn't realize the process, especially if I'm a mail-in voter, that I have to actively tell my recorder which party ballot that I want. Oh, I don't get a single ballot that has all the candidate names on there. I'm an independent. I don't want to associate with the party. So when the media is covering elections, we have to make sure that they are educated as well on this nomenclature, on the terminology and what it means and the different pathways for each voters. So there's a lot that is impacted by this decision, and we are currently right now communicating with our election colleagues, with the county recorders. As Tom mentioned, this change is going into effect December 1st. Our immediate goal would be for those voters who are going to be updating or new registrants once this change goes into effect, that they have some clarity on what their choices mean. So we are looking at right now kind of documenting what those pathways are, ideally getting something up on our website as soon as possible, and then developing educational assets to help explain that voter registration touch point. So again, if you choose to register to vote as a Republican, here's the pathway it sets you on for the primary. If you choose to register as an independent, unaffiliated other voter, this is the pathway that you are sent on. And then if you choose to register to vote with the Arizona Independent Party, this is the pathway it sets you on for the primary. We are hoping to collaborate with our county recorders and develop or work with them in potentially work groups, meetings, to collaboratively create these educational tools and resources for voters. And I think, we've seen a lot of ask from our election colleagues here. They are looking for this support. So as part of our efforts to provide voter education to the entire state, it really is critical that they get that first step of voter registration correct, that it's what they truly want, and that they understand the pathway it sets them on when they are interacting with a primary election. So that's, again, sort of our strategic viewpoint on how to tackle this issue, which will, again, be ongoing. But with that, I'm happy to answer any questions that the commission may have.
Thank you, Gina. If I could summarize what Gina said in one word, it's confusion. And I'd like to just give a little elaboration on that as an independent, both as a member of this commission, and also I work as a poll worker in every election for, I don't know, more than 10 years. And independent voters are already confused when they show up, particularly in a primary, as you mentioned, Gina. They don't know if they can vote, and most of the time, in the vast majority of the time, they don't vote, despite our best efforts to educate independent voters that they can vote. Then they get in there and they're asked, which party do you want, and do you want a ballot for? And that further confuses them. And so there's already a lot of confusion for independent voters. And this is just going to multiply it. I can't even say how badly. It's going to just make it confusion times 10 if this proceeds. Do any member of the commission wish to ask Tom or Gina any questions?
Mr. Chairman?
Commissioner Crump?
Yeah, thank you. I do have what I think is an important, at least for me, an important threshold question before we get into the merits on this argument. And that is, I want to understand the commission's options / authority on this question. What is, let's say we determine, yeah, this is terrible, we need to do something about it. What is it that we're empowered to do?
Tom,
Sure.
do you want to address?
Sure, Mr. Chair, Commissioner Crump. I mean, I can sketch that out. I mean, and Bill may have some thoughts on that and how we want to handle how we answer that and where we answer that. To something I'll just defer to him on. I would just say this: looking at this just as a matter of the commission's, to the extent we have a bully pulpit, I think that we do have that by virtue of legitimately by virtue of both our express role in providing the voter education guide for the primary, and in terms of our overall authority to educate the public on participation in elections. So, and I think that comes up in multiple touch points, whether it's our debates, whether it's the candidate statement pamphlet, those things, right? So at every point that we have to utilize the term Arizona Independent Party, which is a lot, or at every point where we have to explain to a voter what their rights are doing, which is a lot of points, right? That's just it runs throughout our program. So I think that in that sense, to say you would have to take from a sort of authority with which to speak from, I think you would have to carve quite a narrow path to just say that the commission would be speaking out of turn, or that this meeting is out of turn, or anything like that. I think that would be a pretty preposterous kind of position to take. Although when we've spoken out on things, people do take that view. On the legal front, I think that there are a lot of there's a sort of a highly how to put this, as we've already experienced in other litigation we're involved in, there's a whether or not somebody has the authority to go into court is a question that's always an open question. I think it's safe to say. And and so I guess I would leave it at that from my perspective, and then Bill, to what extent you feel comfortable here, or and Chairman, if what point if you want to talk about that. It really, Mr. Chairman, Commissioner Crump, it really depends on. Do you want like an answer to the ultimate question of, does the commission have standing to go into court on its own? Is that the question?
Yeah, Commissioner and Tom. Yeah, I mean, I guess, especially because we're in a time crunch, if we're trying to do something about this election, or is it the commission that's going to be going out seeking a preliminary injunction and so forth to deal with this?
Well, Mr. Chairman, as a preface to whatever comes next, I mean, I will say that I'm aware there's a lot of discussion in the legal community about various legal actions. But on that specific question, I mean, that's really I would defer to the chairman and Bill about how you want to handle that in terms of where to answer that question.
Mr. Richards, is there anything you'd like to add on this?
Thank you, Mr. Chairman. I think the specific discussion about legal options in terms of judicial options, litigation probably is best addressed in executive session. I will say, though, that I think there is on the table a variety of different options that would be available to the commission. Everything from public statements to direct contact and communication with the Secretary of State's office, and to include litigation. And I'm happy to address some of those issues more specifically, but I think it should be best done in executive session.
Okay, thank you. If I could summarize, we basically have two broad issues here. Number one, it doesn't appear that there was any clear process carried out by the Secretary of State's office to approve this change, and should we do something about that? And number two, Gina's side of it, what are we going to do going forward? So those are, and I think the first part of it, is something we're going to have to discuss in executive session. But there are other things we may want to discuss here if any other members of the commission want to discuss it. Commissioner Payton?
Yes. I would, have there been any discussions, Tom, with Secretary of State's office? I mean, yes, no, or?
I mean, if I was to characterize the discussions we've been permitted to participate in with the Secretary's office, I'm not under the impression that the Secretary's likely to change their mind based on just being asked to. All the things that we've talked about here in terms of the confusion, the impact on the counties, these are all things the Secretary's office is well aware of. They've heard it from the counties. They're hearing it from the counties. It's to some extent that Secretary of State's office position is along the lines of, we don't have any authority to do anything but grant this request. That's effectively what their memo says, and that's also what their subsequent statements to the particularly in that Arizona Central piece that I sent along seems to say. So that's not a, and at the same time, they're pressing forward with the changes that they feel like they need to make. So, I'm not, in other words, while I think there would be value in a direct communication on behalf of the commission that says, by the way, we really think this is a bad idea, and we think it's a bad idea for all these different reasons, and that was in the form of some kind of letter from the commission. That is a meaningful thing to do because it creates a record that's maybe more formal than what they otherwise have, that says that these are in fact concerns that are grounded in law and are and reflect I think a broad consensus among other election officials.
So we could make a plea, a petition to them,
right?
Written,
yeah.
And
do
you think that's worth the time, or?
Well, I think I certainly think it's worth the time, with the caveat that its likelihood of changing the outcome here is, I would say, around zero on its own. I mean, they know what people feel. They're well aware of what's going on. They're not, they're sophisticated political and legal and administrative agency. So I value to do it for record purposes, for lots of reasons. value to do it to achieve the end we're talking about? Not so much, but that doesn't make it valueless.
Let me follow up by asking a naive question. Has anyone talked to Paul Johnson of the former No Labels Party saying, we understand you probably did this to raise the registration of your party, but there's a lot of unforeseen impacts of this. Would you reconsider, or is that pointless?
I'll be honest. Well, Mr. Chairman, it never occurred to me that that would be of any value.
Any other comments or questions from the commission?
I would just say that it just seems like they want to, I mean, this seems obvious to me. They want to co-opt or I don't know, like trick or whatever, the 1.5 million people that are described in this list as other, who want to be, who don't buy into the two major parties, and for whatever reasons, and there's a whole gamut of those reasons, and the other group here is only about 57,000 people less than the Republican Party. I mean, that it dwarfs, the Democratic Party. And I think that it seems like it's a deliberate attempt to confuse people, to co-opt them to join their party because they only have 42,000 people. And I think that having the No Labels name was a good attempt at starting a new deal. And I just think that this is, my wife's an independent, and she already, like the chairman says, she's already kind of confused at times as to what she can do in primaries and so on. And she's got 3 degrees. So this is just heaping on the confusion, and I think we should at least make an attempt to publicize that fact. I don't know how much power we have, but maybe we should go into executive session.
Commissioner Werther, did you have something you wanted to say?
Yeah, Mr. Chairman, and this is mostly on the voter education piece. It's really more of a comment, but I am concerned, deeply concerned, because we are already in the midst of preparing for 2026. And so this is very late. I know to maybe a lay person, it might not seem like that. It looks like we still have, until next August, but candidate filing starts in early March. And so this is already, I think, going to really complicate things for candidates and voters. And I think I'm also concerned that whether litigation is brought forward or whether there's legislation that's brought forward, how that's going to impact this at a very, we're only going to get later into the election cycle. And so I think whatever we can to start supporting, the voter education efforts to at least get this information out there, so that people understand that something's happened, and then they know where to come back to for the most updated information, I think is really important. And I also would be in favor of any type of letter. And I also recognize that it likely will not change the outcome, but I do think it would be important to put on the record the concerns that we've all raised here for both candidates and voters, especially in this next election cycle.
Thank you. Thank you. Any more comments from members of the commission?
Yeah, Mr. Chairman.
Yes, Mr. Crump.
Thank you. I would like to point out a few things on this before I was just asking that authority question, but my comments as to the merits of this, I completely agree with the voter confusion issues. I think this creates a ton of administrative work, and to that end, it seems like if all a party has to do, an existing party, to change their name is to submit a letter, what stops them from just playing games and doing that every election, right? And imagine all the administrative work that creates. I would also like to point out that I don't think that the statute is silent on this, which the Secretary of State seems to have alleged. I think the statute is clear, and it says that there's one way to name your political party. That's in 16-801, and that's the gathering of signatures and so forth. And in fact, that's bolstered by other parts of the statute. 16-901 says that it is if a committee. I'm sorry, that it's a committee. The requirements of 801 makes you a committee, and 1905G, a political party can register only as stated in 16-801. So I think the statute has been made clear, and if the legislature wanted to have a way to simply amend your name as a party, they could have done that. So I also want to make the commission aware that just recently, sometime in the past, the New York legislature passed a ban on using the term independent in a political party name. But just in August of this year, a candidate challenged that, and the federal Second Circuit Court of Appeals upheld the law and said it's not a violation of his First and Fourth Amendments. So I think that's very useful to us. I am interested, I guess, to know what staff might say. Are there any particular problems regarding a federal party? I don't know how that works when you've got somebody registered as a national party, and if they have independent in their name, and then they want to be that party in Arizona. So, there's the National Libertarian National Party, for example, and then there's the Libertarian Party of Massachusetts. But if a national party had independent in its name, and we somehow banned the use of independent, how does that affect them on the state level?
Mr. Chairman, Commissioner Crump, the way I would address that question is this. I think that from an organizational perspective, for that party to organize in Arizona, they would have to go through the petition process. I'm not aware of any other way they could do that, simply by being having a national organization. And in fact, my understanding, for all I can understand, that's what happened here. There is some national no labels party, and that national no labels party is what sponsored or paid for the organization here. If the word independent were banned as a party, or some other ban was put in place that said you can't have a confusing name, or whatever you want to say, which I'm not sure you actually need that ban. I'm not sure that's not implicit in a rational reading of the statutory scheme, right? I mean, but put that aside for a second. I think the burden would be on them to show. Well, the first question would be, is that a significant burden on them such that it would be subject to strict scrutiny, in which case they would probably win. That's the first step. But if it's not subject to strict scrutiny, then the analysis proceeds to look at the burden on them versus the state's interest. And that is that can be unpredictable, surely. But that's how the analysis would proceed. So if an absolute ban on a particular word was considered to be a severe burden, then that would, I mean, even though you apply strict scrutiny, it would effectively end the analysis under the First Amendment test. And if it's not a severe burden, then you get into this more balancing test, the state's interest. And it sounds like, I have not read the Second Circuit case you mentioned, but it sounds like that's what the analysis they undertook there with respect to that issue. I've not done a full rundown of every database to determine what has happened. I do know from the No Labels Party's own memo that people have changed their name to independent party in other states. The memo itself, which is the entire record here, administrative record, as far as I can tell, is the letter from Paul Johnson to the secretary and the secretary's letter to Paul Johnson back. There's no other record. And in tracking down the circumstances of those name changes was not something I was able to do easily. And the letter doesn't tell you what the process was, what the other existing law was, what the timing of it, all that other kind of stuff. I mean, at a minimum, it seems to me that the Secretary of State had discretion, even no matter what the circumstances, to say, not now, right? He didn't have to say not at all, but he definitely had the discretion to say not now, assuming this is in a discretionary decision. Now, there's reasons why you wouldn't want to see it. You want to, that there's ways to look at this that goes well beyond outside of whatever his discretion is. But, clearly he wouldn't abuse his discretion by saying, we're not going to do this election cycle, come back in November of 2026.
Okay, thank you. And also, Mr. Chairman and Tom, on a separate issue, whatever this is called, your continuing status as a party. So when you first get on the ballot, you're there as sort of kind of in a probationary status the first couple of election cycles, I guess, and you have to have certain registration and/or votes in order for you to be a continuing party. Am I summarizing that correctly?
Yes.
Okay. And so I think also another point in favor of those opposed to this name change is that I think my point is, I think you've earned that right by using the name that was on those petitions, that was on the ballot, to earn that continuing party status.
Right.
And that if you're going to change your name, you got to start the process over, because that wasn't the name of the party that earned that continuing status. Does that make sense?
So, Mr. Chairman, Commissioner Crump, there's a line in the Ninth Circuit case from July. There's a footnote in it that talks about how, had the No Labels Party, that was the circumstances where the No Labels Party wanted to say, no one other than president can run on the no labels line in Arizona. And the state's position at that time was, no, you've signed up for the full, thing, and we're going to have and you ought to have a primary. The Ninth Circuit says, among other things, it said, by the way, had you said in your petition, we are a party that will be organized solely for the purpose of the presidential election, we don't know if that would have resulted in the same outcome with respect to the petition. And here, to the extent there is a petition process that is public, that itself is a legislative determination that there's going to be notice, right? There's going to be notice to the public by virtue of this petitioning process. The using a different name would have necessarily changed who might have signed. It would have necessarily changed the nature of the information provided to the broader public and other interested parties, which is the purpose of the petition in the first place. And so that aspect of what the Ninth Circuit said in July, I think, is salient here, and to your point, which is, if the petition process means anything, then a court ought to consider the possibility that a change after the fact that would have impacted the petition process changes the entire notice process leading up to the formation of the party. And I and you can quibble about that as you can argue about the scope of that concern, right? But you can't just but you have to argue about it. You can't just say that's not a concern here.
Right. Thank you.
Any other comments or questions from members of the commission? Is there any interest in discussing this further in executive session? Commissioner Werther, you seem to be ready to talk.
So I am interested. So I'll just go ahead and make a motion and we'll see where it goes. So I'll just move to go into E-session for public discuss, or I'm sorry, for discussion and consultation with our attorneys to consider this matter.
Thank you. Is there a second?
I'll
Second.
second.
Good.
Seconded by Commissioner Payton. I will call the roll on the motion to go into executive session. Commissioner Werther,
Aye.
Commissioner Payton,
Aye.
Commissioner Crump,
Aye.
Commissioner Titla.
Aye.
Chair votes aye. We are going into executive session. Good morning again. We're back in regular session. Is there a motion any member of the commission wishes to make?
Yes, Mr. Chairman.
Commissioner Werther?
I move to direct staff to prepare a letter for the chair's signature requesting that the Secretary of State reverse the decision relating to the Arizona Independent Party and approve the engagement of counsel to work with staff to develop legal options should the Secretary's office choose to reject the commission's request.
Is there a second?
I'll second.
Thank you. It's been moved and seconded by Commissioner Payton. Moved by Commissioner Werther and seconded by Commissioner Payton. I will call the roll. Commissioner Crump,
Aye.
Commissioner Titla,
Aye.
Commissioner Werther,
Aye.
Commissioner Payton.
Aye.
Chair votes aye. The motion is approved 5-0. Thank you. We're going to delay item 5 to our next meeting. So we'll move into item 6, discussion and possible action on amendment of Rule R2-20-106 related to candidate verifications before issuance of clean funding, and adoption of R2-20-706 relating to repayment proceedings in the event of unfiled campaign finance reports. As you will recall, we opened a rulemaking docket on these rules to help reinforce the need for timely filing of reports. The first of these amendments says that where a candidate qualifies for funding because this does not happen, let me rephrase that. The first of these amendments says that where a candidate qualifies for funding because this does not happen on the same timeline as reports, they will have to reaffirm their compliance. The second rule says that if a candidate fails to file a campaign finance report within 5 days of the due date, the staff may initiate repayment. This will ensure that candidates know that filing timely reports, as they agree to, is an important part of the accountability in the program. We will make this effective immediately pending review by the Governor's Regulatory Review Commission. Any questions for Tom about this? Hearing none, do we have a motion to approve R2-20-106 and 706 as amended?
Mr. Chairman, I move to approve the Rule R2-20-106 and R2-20-706
As amended.
as amended.
Thank you. Commissioner Werther, is there a second?
I'll second.
Thank you, Commissioner Payton. It's been moved and seconded that we approve R2-20-106 and R2-20-706 as amended. I will call the roll. Commissioner Crump,
Aye.
Commissioner Titla,
Aye.
Commissioner Werther,
Aye.
Commissioner Payton.
Aye.
Chair votes aye. The motion is approved 5-0. Item 7, public comment. This is the time for consideration of comments and suggestions from the public.
Appreciate it.
Action taken as a result of public comment will be limited to directing staff to study the matter, rescheduling it for further consideration, or responding to criticism. Please limit your comments to no more than 2 minutes. Does any member of the public wish to make comments at this time? Anyone on Zoom wish to make comment? There's no one present in the room. No one on Zoom wish to make a comment. Thank you. The public may also submit comments by email at ccec@azcleanelections.gov. Item 8, adjournment. This time I would entertain a motion to adjourn.
I move to adjourn.
Thank you, Commissioner Werther. Is there a second?
Second.
Thank you, Commissioner Payton. It's been moved and seconded that we adjourn. I will call the roll. Commissioner Crump,
Aye.
Commissioner Titla,
Aye.
Commissioner Werther,
Aye.
Commissioner Payton.